The Supreme Court on Thursday by 4:1 majority upheld the constitutional validity of Section 6A of the Citizenship Act 1955 that confers citizenship on a specific class of migrants from Bangladesh to Assam. The 5 judges bench that delivered this judgment was led by Chief Justice D.Y. Chandrachud and comprised Justices Suryakant, J.B. Pardiwala, M.M. Sundaresh and Manoj Mishra. While Justice Suryakant authored the lead verdict on behalf of Justices Sundaresh, Mishra and himself, Justice Chandrachud wrote a separate verdict elaborating his reasons on why he supported the majority view. Justice Pardiwala wrote a dissenting verdict and declared Section 6A of the Citizenship Act invalid with prospective effect. Now, this decision came on a batch of 14 petitions that challenged Section 6A's inclusion in the Citizenship Act through an amendment in 1985. The majority verdict held that the legislative objective of Section 6A was to balance the humanitarian needs of migrants of Indian origin and the impact of the migration on the economic and cultural needs of Indian states. Its implementation following the Assam Accord brought quietus to the then ongoing discord in the state while concurrently enabling India to uphold its diplomatic commitments to Bangladesh and address humanitarian concerns. The sole dissenting judge, Justice Pardiwala, however, said that the section has become invalid with the afflux of time. In his opinion, Justice Kant, speaking for 2 more judges, acknowledged the concerns surrounding illegal migration and said it needs to be addressed. Due to porous borders and incomplete fencing, the unceasing migration imposes a significant challenge, he added, while holding there was inadequate enforcement of the scheme under Section 6A that aims to restrict illegal migration post-1971. Importantly, Justice Kant called for judicial monitoring of the implementation of immigration and citizenship legislations, which he said cannot be left to the mere wish and discretion of the authorities. In this video today, I will tell you more about this judgment, the core issues that were argued in this case, and the factors that led to the bench to uphold Section 6A. But first, what is Section 6A? In 1985, the Indian Citizenship Act was amended to include Section 6A. This provision was introduced following the signing of the Assam Accord between the Government of India and agitating groups in the state. It granted citizenship to persons of Indian origin who migrated to Assam from Bangladesh before 25th March 1971 and established a framework to delineate criteria for the same. The provision classified the class of migrants into 2 categories. This classification was based on when the migrants entered Assam. So essentially, those who entered Assam before 1st January 1966 were deemed to be citizens of India if the person was of Indian origin or if they or either of their parents or grandparents were born in undivided India. The second category was those who entered Assam between January 1966 but before 25th March 1971. Such persons were required under Section 6A to register themselves to secure citizenship. Though such persons were allowed to be listed in the electoral roll of Assam, they were barred from casting their vote in any elections in Assam for a period of 10 years. But they were given the same rights and obligations as citizens of India. Section 6A granted no protection to those entering Assam after 25th March 1971, thereby rendering their presence in India illegal and making them liable for deportation. Why was 6A challenged? The first writ petition challenging inclusion of Section 6A in the Citizenship Act was filed in 2009 by an Assam-based NGO, Assam Public Works, seeking deletion of illegal migrants from electoral rolls in Assam and updation of the National Register of Citizens. 3 years later, more petitions were filed. By the time this matter was ready for a final hearing in October 2023, the list of such petitions against Section 6A grew to 14. The petitions raised multiple questions such as whether the grant of citizenship to migrants from Bangladesh to Assam was within the legislative competence of Parliament under Article 11 of the Constitution that gives Parliament the power to make laws about citizenship, whether Section 6A adopts unreasonable cut-off dates for regularizing illegal migrants and singles out Assam, in the process violating Article 14 that ensures equality for Indian citizens. Let me tell you here that we did a detailed discussion on this issue in one of our Laws of the Land episodes. I will share its link in the description below so that you're able to understand the core arguments that were raised in the court during the discussions. During the hearing, both Assam and central government supported inclusion of Section 6A. Apart from contesting the petitions on merits, the two sought dismissal of the petitions at the threshold because, according to them, they were filed 27 years after Section 6A was introduced. Centre and Assam submitted the issues involved in them related to India's foreign policy, traditionally kept out of the court's purview. Now let's come to what the court held. The majority view of the Supreme Court refused to dismiss the petitions at the threshold and chose to deliver a detailed judgment considering the petitions raised significant public policy issues that involved ramifications for the original inhabitants of Assam, their rights of immigrants, and security of the country. After dissecting the legislative history of Section 6A and the background in which it was introduced, the majority opinion said Section 6A falls within the bounds of the Constitution and does not contravene the foundational principles of fraternity, nor does it infringe upon any one of its provisions. Section 6A, rather, the court said, aligned with the concept of fraternity as it stands today, which allows people of different backgrounds and social circumstances to live and let live. It added that fraternity cannot be understood in a narrow sense to hold that one should be able to choose one's neighbors. The court further held that Parliament was competent to prescribe different conditions to grant citizenship. Further, the majority view dismissed the petitioner's assumption that Section 6A allowed dual citizenship to the migrants from Bangladesh. Due to petitioner's specific contention that Section 6A's exclusive application to Assam made it violative of Article 14 that guarantees equality to all citizens, the court said it found that the classification made through this provision was reasonable and intelligible. This provision, it said, was introduced out of humanitarian concern as it was deemed inhumane to repatriate thousands of people who had migrated to Assam during the 1971 war. Further, the considerations of interstate relations were pivotal as India sought to extend cooperation to the newly formed nation of Bangladesh and helped it in restoring normalcy. It said that section was introduced pursuant to the Assam Accord that agreed to grant Indian citizenship to limited category of immigrants from Assam and also extended benefits to those who were involved in the agitation against the influx of illegal migrants. The section also focused on socio-economic development of the state. Section 6A, the court held, was accorded to advance the political settlement established through the Assam Accord. The court refused to comment on whether the centre should have entered into similar agreement with other states that also witnessed similar influx of migrants. It observed that political compromises and agreements are a prerogative of political entities. Further, according to the court, the petitioners had failed to demonstrate that the provision introducing a cut-off date for citizenship exclusively for Assam was unreasonable or capricious or whimsical. In the court's view, the process outlined in Section 6A for migrants to secure citizenship was neither irrational nor vague and was rather more akin to a beneficial legislation. After a careful examination of the petitioner's charge that Section 6A has led to drastic demographic change resulting in the loss of Assamese culture, the court said the material on record did not substantiate the claim. In their argument, the petitioners had actually contended that the influx of migrants from Bangladesh had led to substantial acquisition of land and scarce resources by immigrants had marginalized the original Assamese inhabitants within their own territory. However, the court viewed that all citizens have the right to own property and unless restricted by statute or any other law, they are free to enter into private land transactions. The court did not find merit in the petitioner's submission that Section 6A had conferred political rights upon millions of Bangladeshi migrants who continue to pose a severe threat to the people of Assam. It refused to direct en masse removal of the migrants who got voting rights by virtue of becoming Indian citizens. The court, however, gave liberty to the petitioners to seek legal remedy under election law in case an ineligible migrant is included in the voters list. On whether citizenship to migrants under Section 6A would constitute internal disturbance or external aggression, the court said no. Hence, it ruled that this provision was not a violation of Article 355 that requires the central government to provide adequate protection to states from external aggression. Section 6A, the court held, addressed a controlled and regulated form of immigration which was crucial to bring quietus to the political upheaval in Assam.